Well, hey again, everyone. It's Rob Ryder, and it is Monday, the 6th of May, 2024. And today, find truth in lending and own the bank. Maybe the banker, figuratively speaking, of course. This has to do with, every kind of consumer loan has some kind of regulations attached to it, and one of them is the Truth in Lending Laws Act. And, like in most things, it doesn't appear that they follow that either. But nevertheless, if you can find the errors and omissions, is there something that you can do? Because these are contracts that we're talking about that have both your signature and the signature of the other company. So, for instance, your telephone. If you have a mobile phone, right? You have a contract, and if you follow the paperwork, you'll see someplace where both parties signed. Same thing with a car loan. Now, I'm going to assume it's the same with real estate, although I haven't seen it yet, but I've seen it talked about, real estate, truth in lending and mortgages. So you would say, well, that must be the same for real estate then. And credit cards, I believe, have something to do with the same thing. And so, well, what the heck is truth in lending, and what can we use it? Can we use it for our advantage? So that's kind of what's going on. This is all resulting from having worked with Kimberly in Texas on her real estate transaction, where she's not in foreclosure necessarily, but she stopped making payments because, well, for one thing, that they changed the address and the name of the business to send the checks to. Right, and she had watched some of my videos over time, got in touch with me, and we started some stuff that started in a small claims court. And I started it there because we were going to go after the earnest money that she had put up, because the broker had never transferred her the legal title. Now, the idea wasn't to ever go to small claims court and have a trial. The idea was to get them to negotiate and give her the legal title, because if they went to court and they were to be found guilty of a deceptive practice, well, that's it's a misdemeanor. They might have to go to jail. And then, then the judge can do whatever the judge wants once he gets a ruling. But, again, the idea wasn't, well, let's go to small claims court for $3,700. Let's go to small claims court because we can say we're going after the earnest money, which is like $3,700, fits within the criteria of small claims court, yada, yada, yada. And so I'm going to be doing a video about where that is right now. But one of the things in there was that as part of a pretrial conference to decide if you wanted to have alternative dispute resolution. And that's really what we're going for, is alternative dispute resolution by way of mediation, first of all, which is going to happen in a couple weeks. So anyway, so that's what's going on there. But from that, because she had these other things she was dealing with too, we started looking at some of the other, bills and things with contracts and what they say and so forth. And that's what we're going to show today. You have a number of things that you do have quite possibly some form of a contract between you and a commercial entity, phone company or credit card company, whomever it is. So let's see what the contracts say. So give me just a second here and we shall get started. So if you haven't seen any of these last few videos I've done on looking at a mortgage, deed of trust, and looking at everything it says and trying to decipher the deceptive practice going on. Excuse me, not deed of trust, just the whole transaction. Because the deed of trust mortgage, the money part of a real estate transaction is totally separate from the title part of the transaction. And I talked about that in these videos here, combating deceptive practices, one of however many, and then deceptive practices, part 2B, another one. And then ADR, ordered by a small claims court. Because one of the things we did then was put in to ask for alternative dispute resolution, and it was granted. And yeah, but so that has to do with mortgages and what will be happening here soon because of the mediation that we're going to be going through. So way back in 1968, they passed Public Law 90-321, which the short title says it was this act may be cited as the Consumer Credit Protection Act. When you go a little farther down and you get into it, it says, well, this title may be cited as the Truth in Lending Act. So it must be just a particular portion of the Consumer Credit Protection Act. That's very good. So what's it for? Well, what's a credit sale? That refers to any sale with respect to which credit is extended or arranged by the seller. The creditor refers only to creditors who are regularly extend or arrange for extension of credit, for which the payment of a finance charge is required, whether in connection with loans, sales, property, services, property or services otherwise. Right? So what do you have them for? Well, there's creditors involved whenever there's finance charges involved. Term credit means right granted by a creditor to a debtor to defer payment of a debt or to incur debt and defer its payment. Okay? Well, let's see what that is. Just a second here. Okay, then you have some exemptive transactions. We're not going to look at much of this, but I wanted to show this, right? This is the determination of finance charges. So, except as otherwise provided in this section, the amount of all finance charge in connection with any consumer credit transaction shall be determined as the sum of all charges payable, directly or indirectly, by a person to whom the credit is extended. So, a finance charge is sum of all charges payable directly or indirectly. And they include interest, time, price, differential, any amount payable under a point discount, other system of additional charges, service or carrying charge, loan fee, finder's fee, similar charge, fee for investigation or credit report, premium or other charge or a guarantee or insurance protecting the creditor against obligor's default or other credit loss. All right, so that sounds pretty reasonable. There was annual percentage rate, which is the other one that goes with this. So determining annual percentage rate, the annual percentage rate applicable to any extension of consumer credit shall be determined in accordance with the regulations of the board. In the case of an extension of credit other than under an open-end credit plan, as all right, so an open-end credit plan, I believe that'd be like for a credit card, or auto sale or phone sale or whatever. That's not necessarily the open credit plan. Although I could be totally wrong. I mean, a car or your telephone could be open credit plan too, as far as that goes. The nominal annual percentage rate, which will yield a sum equal to the amount of a finance charge when it is applied to the unpaid balance of an amount financed, calculated according to the actuarial method of allocating payments made on debt between the amount financed and the amount of the finance charge, pursuant to which a payment is applied first to the accumulated finance charge and the balance is applied to the unpaid amount financed. Okay. Now, I don't really understand exactly what that means, but let's go look and see what it looks like on paper. So hang on a second. Okay, so there's a fairly good chance you've seen a truth in lending disclosure before, right? Looks something like this, Federal Truth in Lending Disclosure. And a retail installment contract. This one happens to be for the purchase of a used vehicle. And shows in here the itemization, the amount financed, right? So you had the cash price, subtract your down payments, right? Add what goes to public officials for license, title, registration fees, taxes, other charges, so forth and so on. And eventually you get to the amount financed, right? So this is the amount that the vehicle is going to cost you, based on the sticker price and them working their numbers. And we go down, boilerplate. You get to the last page, and sure enough, got buyer signed it, and so did the dealer. So, it doesn't say he's the creditor. It says he's a dealer. So I don't know where exactly the credit came in. But let's see what they did. So you, the buyer, shown above, agree to buy the motor vehicle described below on credit, subject to the terms and conditions on this credit and security agreement contract. Now, on this credit, or on this contract, and security. So I don't know if there's a separate security agreement that's saying, or is this supposed to be a combination of both? But I'd be asking, well, where's the security agreement? But by signing below, you will agree that you have been quoted one cash price for the vehicle. We, us, and our refer to the dealer shown above and any person to which we may transfer or assign the contract. See here, though, it says dealer/creditor. So at that point, you really wouldn't know, well, is it the dealer or the creditor? Or is it both? Hard to say. So we're buying a Lexus. This is back in 2019, right? So 2003-year-old Lexus. And no trade-in. And then we get to the Federal Truth in Lending, where it says, well, the amount financed. Let's start there. The amount of credit provided to you on your behalf. 25,334 credits. Finance charge. The dollar amount the credit will cost you. $7,737. And then they give you this annual percentage rate of 9.157%. Which is supposed to be calculated by using that system that we saw back in the law. All right, and then they took total payments. The amount you will have paid when you have made all scheduled payments is going to be $33,000. And the total sale price cost, including your down payment of $2,000, so $3,500. So basically, so it was $3,500 for, something you financed for $25,000, but actually it's $35,000. You paid $2,000, and they're saying you still owe $33,000. But that isn't what this says. It says the amount financed, the amount of credit provided to you on your behalf, $25,000, and that those credits cost you in dollars $7,700 and some dollars. So really, what this is, it's almost like a foreign exchange agreement, where for, let's say, $8,000, you're going to get $25,000 in, a foreign currency called credits. And you need those credits because that's what the vehicle is denominated in, is with credits, not with dollars. And I know it has a dollar sign here, but, there's like 28 different currencies that use the dollar sign. Like the Ecuadorian dollar. I think it's worth, just cents, 11 cents, 20 cents, something like that of a dollar, right? So you see a dollar sign, you could pay them in Ecuadorian dollars. But in this case, this is debits and credits, right? It's not dollars. You're not buying a car for dollars. You're buying a car for credits. So it's a foreign exchange. And so technically, the car should have cost you $7,737. They shouldn't have taken that number, added it to that number, and said, well, there's your total, and they gave us $2,000 in, now this is what you owe us, and here's your payments. But that's what they did. Right? But that is what a finance charge is. All right? Finance charge. In connection with any consumer credit transaction shall be determined as the sum of all charges payable directly or indirectly by the person to whom the credit is extended. It's supposed to be everything you have to pay. It includes the interest, right? So the interest for the loan, the time, price differential, any amount payable under the point system, service, and so forth and so on. All those things. But, at the end of the day, that's what you borrow. Now you say, well, that doesn't make any sense. I mean, that can't be. I mean, you can read it and you say, well, yeah, it makes sense, but that don't make any sense. It says it's going to cost you this much, $7,700. Now, how come I'm making 72 payments at, $450 a month? Well, because you agreed with them, right? You didn't say, well, no, that isn't what the agreement is. So if that had been and you were paying, let's say you were paying $460 a month, right? Then it'd be 10. In less than 20 months, you'd have the whole thing paid off. Where this is showing you're going to be paying it off for, 72 months. Where in actuality, you can have it paid off in, half that time. So there's something going on here. All right, then it says promise to pay and payment terms. You promise to pay us the amount financed. Right, $25,334. That's the amount financed. Plus finance charges, I should say comma, plus finance charges occurring on the unpaid balance at a rate of 9.157% per year, the contract rate, from today's date until paid in full. Finance charges occur on the true daily earnings method. As outlined above in the Truth in Lending Disclosure, you agree to pay this contract according to the payment schedule by paying the amount stated in the total of payment box or a greater amount. You also agree to pay the late charge shown above, any amounts according to the terms and conditions of this contract. Well, the thing is that the $7,700 is paid for the credits, so the credits are no longer part of the issue. So it's like, well, okay, I paid you your amount financed. Right? Now, the finance charge is occurring on the unpaid balance. Well, there won't be any because you paid it. Right? So again, I just say, well, those that this credit, $25,000 and change, cost you just short of $8,000. But dollars are not credits, and credits are not dollars. It's a foreign exchange. And the other thing is that in here, you'll see that you paid for the license, title, registration fees, and so forth, and yet they never transfer you the title to the car. Well, that's deceptive practice. So, that's what I'm saying. So what do you do about it? Well, you find out that eventually, if you read through these things enough, that you have an arbitration agreement. The arbitration agreement entered into between you and the dealer is incorporated by reference into this and is a part of this contract. So I don't know where exactly it is, but it turns out that in most of these auto transactions, it's a place called AAA, arbitration. Right? And so you can go there and arbitrate the contract instead of going to court. And arbitration is supposed to be done in good faith, which is a big deal, because the Supreme Court has said that the courts have no jurisdiction in matters of faith. It don't care if the record is that way it is because of good faith or bad faith. It just cares what the record is. Where we care what the record is based on the faith of the record, which was it done deceptively or was it done in good faith? Well, if this was done in good faith, then this contract should cost you for this Lexus should be just short of $8,000, not the 25 they said it was. Then they add the two together and say, well, now you actually owe us this. Now let's look at another one just as an example, right? Because this is for the vehicle, or not for the vehicle, for a telephone. Right, so Kimberly went down, wanted to get a new phone plan, went down to the T-Mobile store, started signing papers, and they have you sign this equipment installment plan, which says that the dollar amount of the credit will cost you is $0. The amount of credit provided to you on your behalf is 282 credits, not dollars, credits. So the credit didn't cost you anything. Now, they went ahead and said, well, we're going to take that and split it up and do it this way, but that isn't what this says. This says the dollar amount the credit will cost you, 0.00. No annual percentage rate. It doesn't cost you anything to have a telephone. And we'll go through this some more. Now, this one I have a little more information to show you, but we're going to use this as our example with what the contract and so forth says. All right, there's the cash price. Prepaid finance charge, 0. Unpaid balance of cash price or unpaid/unpaid balance. 282. Agreement to purchase and make payments, except as provided below. You agree to purchase from seller the items described above on terms set forth in this agreement. Affiliates of T-Mobile Financial LLC, which is actually the name of the company that you have the agreement with. That's who you're contracting with on this contract. So, but they say they're affiliates, right? So affiliates of T-Mobile Financial LLC. Then they tell you it's T-Mobile Financial without the LLC. Well, that's one of them. And together with its affiliates. So now T-Mobile Financial has its own affiliates outside of the affiliates of T-Mobile Financial LLC. T-Mobile, we, us, or our provide wireless service to you. The service subject to our delivery to you of the equipment identified above and purchased by you, and subject to your right to cancel this agreement as provided below. You agree to make payments according to the payment schedule above. In addition, you agree to maintain service on any equipment purchased under this agreement for the term of the agreement. If you accept this agreement after the date is made available to you, your first monthly payment may be due 1 month later than the date shown above. The truth and lending disclosure above are part of the agreement. The equipment purchase under this agreement will appear on the monthly billing statements of your service plan. Partial payments may result in suspension or cancellation and an equipment not operating on T-Mobile's network. You may prepay this agreement in whole or in part at any time without penalty. Partial payments will not change your obligation to continue to make scheduled payments, except that you may finish making payments early. This is one-time extension of credit by us to you. Okay, well, so T-Mobile Financial then, LLC, is saying, you're getting your service from T-Mobile Financial. And together with its affiliates, T-Mobile, we, us, or our. Okay, but, it's either T-Mobile Financial, T-Mobile, or something like that. But your agreement is with T-Mobile Financial LLC. And the reason that's important is because when you go to the T-Mobile website, you'll find out, well, they actually have a different name than all these names you see here. But this is who you sign an agreement with, T-Mobile Financial LLC. So be it. Then we go on to see that in addition, in the event that you receive T-Mobile service, the terms and conditions of your wireless service agreement with T-Mobile will apply to this transaction. But if any of those terms and conditions are inconsistent with anything stated in this agreement will prevail. Otherwise, your wireless service agreement with T-Mobile will continue to be valid and enforceable under the terms. Okay, well, what did this agreement say? This agreement said that any credit you get is going to cost you 0.00. I mean, they put 282 because that's what this particular plan costs. But what they're saying is credits cost you nothing. So if you get billed in credits, then they're not going to cost you anything. No matter what your other agreement may say, this agreement says, that it's the controlling one. If any of those terms and conditions are inconsistent with anything stated in this agreement will prevail. And this agreement says that credits cost you nothing. Right? And then we go right into dispute resolution and arbitration. This section describes how any disputes between you and T-Mobile will be resolved. Talk, jack, right? There's American Arbitration Association, yada, yada, yada. Before I move on, right, if we are unable to resolve your claim within 60 days despite those good faith efforts, then either you or we may start arbitration or small claims court proceeding. Right? Good faith efforts. And then that's what the same thing in the court will tell them is that, in court descriptions, it says that, if you take something to arbitration, it's supposed to be done in good faith. Well, only God is good, so now it's God faith, right? You can't use bad faith. Right? At least that's the idea. And so, you read this enough and you say, okay, well, they want you to go on the website and you can download the Legal Center's terms and conditions. Well, when you look at the terms and conditions for this, right on the first page, second page, who is this agreement with? These terms and conditions are an agreement between you, on behalf of yourself, your authorized users, any person on the account, any person allowed to use the services, and us, T-Mobile USA, Inc., and our controlled subsidiaries, assignees, agents, us, we, are, or T-Mobile. Well, this says it's T-Mobile USA, Inc., it doesn't say it's T-Mobile Financial LLC. So if, where's the proof it's a controlled subsidy, assignee, or agent? And who the hell is T-Mobile? Because, very seldom you're going to get anything just in the name T-Mobile. Although I'm going to show you something here shortly. Right? But I'm just saying, well, there's a little discrepancy. This says that you have an agreement with T-Mobile USA, Inc., but the agreement you signed says it's T-Mobile LLC or T-Mobile Financial LLC, and that agreement says that if the terms and conditions of any other agreement with T-Mobile don't match what the agreements did from this one here, right, that this is the controlling contract. So, but anyways, that's on there. And then this talks about, our agreement includes these terms and conditions, the additional terms found, your rate plan and or data plan, your service agreement. Well, I don't know that she had a rate plan or data plan, but she did have a service agreement. Now, the other document that she had to sign at the same time at the store was this service terms. And we're going to get back up to what this is in just a second. But if you look at the service terms, it's for transaction details, account and line description. It doesn't say anything about a plan. Remember, this thing over here said rate plan. All right, well, There's no rate plan mentioned there. This does talk about your rate plan specific terms. You can find it over at T-Mobile, but again, I've yet to see where there's a rate plan. So now this is where she signed. On page 2, and this is a receipt, right? Shows what you paid for. Purchase not on installment, so everything's paid for. There's nothing in here talking about being a rate plan. But there is talk about arbitration disputes. Okay. Now, here's another receipt. I don't know if it's the same one again, but right. There's nothing on here about there being any kind of rate plan. And then somebody's signature. This is odd because it doesn't say whose signature this is, right, in the service terms, but it was done with the number. So we have to assume that this is being done by the other party involved, which is, well, I guess we don't know. Is it T-Mobile? Because they don't say who they are. The only one said it was T-Mobile. Let's go down and look at who signed this thing. Right, there was the buyer's signature. Seller signature, T-Mobile Financial LLC. Well, they didn't do that on this one, so I assume it's T-Mobile of some kind. But your service terms say that your account type is postpaid. Well, that's interesting. What does that mean? This is off of Wikipedia. The postpaid mobile phone is a mobile phone for which service is provided by a prior arrangement with a mobile network operator. The user in this situation is billed after the fact according to their use of mobile services at the end of each month. Typically, a customer's contract specifies a limit or allowance of minutes, text messages, etc. And the customer will be billed at a flat rate for any usage equal to or less than that allowance. Any usage above this limit incurs extra charges. Theoretically, a user in this situation has no limit on the use of mobile services and, as a consequence, unlimited credit. This service is better for people on secured income. Right? You have unlimited credit. If you have a postpaid account, it's an indication you have unlimited credit. Okay, well that's excellent. Now, what did way back when we started? Right, we have unlimited credit. Well, we have an agreement that says any amount of credit doesn't cost us anything. Doesn't matter what the number is. It's 0.00. There is no annual percentage rate. This is the agreement that everything is based off of, is the one that you signed with, in this case, T-Mobile Financial LLC. Right, so there's no charge. It's like, well, your phone service is free. Well, that doesn't stop them from sending mail to you, right? And so you get a bill and it says, well, pay T-Mobile, right? You don't have a contract with T-Mobile. You didn't sign anything with T-Mobile just by itself, right? To some P.O. box in Cincinnati, Ohio. And it came from T-Mobile for business. We certainly don't have an agreement with T-Mobile for business from the things we looked at. T-Mobile Financial LLC. That's who you got a contract with. So, it's deceptive practices. And then they go through the bill and they break it down and, they're showing all these things that really have nothing to do with your agreement with them. But whatever these are all credit numbers anyways. You have unlimited credit because you have a postpaid account, right? Postpaid, unlimited credit. All this stuff is free. And therefore, if you have a dispute, well, then take it to small claims court. Let's see what happens. So that's the plan. That's kind of what we're doing now is they had, like I said, it showed where you could either go to arbitration or you go to small claims court. But I guess they also allow mediation. And that's what Kimberly chose is mediation. And we're just going to go with the simple fact. Well, this is what the contract says, brother. What are we here arguing about for? I got a contract with you that says, that credits don't cost me nothing. And that this contract, supersedes any other agreement. And my agreement is with T-Mobile Financial LLC. And why are you sending me a bill that says T-Mobile for Business on it? Let's get to this one up here. Right? It says T-Mobile for Business. I think there's something fishy going on. Okay. Well, that's really what I wanted to show today. Just this is what it says. So we're going to go argue the fact and see if they operate in good faith. Now, one of the things that happened already in this, because we started this a little bit ago, was soon after filling out paperwork for arbitration for the car, Kimberly got notified that from an attorney firm, because the arbitration place acts like a court, but you don't go to court. Everything's done by email, right? You don't have to go anywhere. Just do it from your desk type of stuff. So they're sending stuff back and forth. And, the attorney firm answers, and the attorney firm says they need a couple more weeks to do whatever, and then they list who the people are. Well, the names that they use aren't names that are on the State Bar website. And it's very easy to argue whether you people have a license to practice law. You need to prove it. If you do, I don't believe that you do. You're not using the name that's on the State Bar website. And in Texas, they actually have a certificate of license that on it is annotated an oath of office, or oath of attorney, as they call it. Well, when you look really closely at what it says, I guess we'll look at one. We'll take that one. Yeah, let's look at what the rules governing admission to the Bar of Texas is. Right, rules governing admission to the Bar of Texas. Adopted by the Supreme Court of Texas, by the way. And so we're going to just search on the word oath. Oath of attorney. So here we go. Rule 2, general eligibility requirement for admission to the Texas Bar. To be eligible for admission, right? So not to be admitted, but to be eligible for admission or reinstatement as a licensed attorney in Texas, an applicant must, all of these, and 8 is, be willing to take an oath required of attorneys in Texas. So to be eligible doesn't mean you've taken the oath yet. It just means you're willing to take the oath, right? If you had taken the oath, then you would be admitted. But until then, you're just eligible if you meet all these criteria. That seems, fairly self-explanatory. And then what do we have here? Oath of attorney. Each person admitted to practice law shall, before receiving a license, take an oath that the person will, so forth and so on. Well, look at that. Support the Constitution of the United States and this state. Honestly demean oneself in the practice of law. Discharge attorney's duties to the attorney's client. Conduct oneself in integrity, so forth and so on. The oath shall be endorsed on the license, subscribed by the person taken the oath and attested by an officer administering the oath. Outstanding. So they do have a license. And if they have a license, then it has their oath endorsed on it. So ask them for it. And that's what we did. Because this is kind of how it looked, right? So last week I was provided the names of 3 individuals claiming to act as counselor for the respondent. None of these names provided are on the State Bar of Texas website. And the closest version of a name I was provided that is on the State Bar of Texas website leads to a profile of an individual that is entitled to practice in Texas. Be advised that entitled to practice in Texas is not at all the same as being licensed to practice law in Texas. And unless these individuals are licensed to practice law in Texas, they cannot act as counsel of the respondent. So why would that be important? Well, because it would mean then that the respondent hasn't answered. If these are the yahoos that are going to answer and they're not attorneys, then the respondent really isn't answering. It's all a freaking sham, right? So default judgment. Anyways, so as it turned out, when they sent it, there were 3 people listed, and this lady was Sabrina Neff, right? This was the information she had put on the letter saying that she was representing the counsel for the defendant. But when you go look online, it's actually Ms. Sabrina Ann Neff. Well, that's not the same name, right? And it says that she's eligible to practice in Texas. Okay, well, it doesn't say she's licensed to practice law in Texas. It just says she's eligible to practice. Well, eligible is not licensed. Rules governing admission to the state bar require oath of attorney shall be endorsed on, license scribed by the person taking the oath, attested by an officer administering the oath that the licensee is issued a certificate of license. And that the licensee is issued a certificate of license. They gave a copy to the licensee. I need to see these individual certificates of license endorsed with their oath of attorney before I can agree to extend the time to answer. Because they were asking for more time. So we just hit them up early. They said, well, you got to prove you're an attorney first. I don't believe you are. Well, the case manager for arbitration wrote back. I guess we had said our thing. They said theirs. We rebutted. And then she said, well, she's going to extend the time, but that we could bring up our issue with the arbitrator, because she's really not the arbitrator. She's just like the clerk putting the thing together in the system. So she noted our complaint and put it in, and we'll see what happens, or we were going to see what was going to happen in arbitration. But since then, Kimberly's decided just to try mediation first, and all these things are alternative forms of dispute resolution. So anything you do other than a trial is alternative dispute resolution. So whatever it gets to get them to agree with us, I don't really care. Now, if you went and looked at this online, right here, State Bar of Texas, and it says here you can put the people's information in, right? Find a lawyer. So Sabrina Neff, as she had put on the document. All right, Sabrina Ann Neff, primary practice location. Don't see anything on there about being licensed. Right? Eligible to practice in Texas. It doesn't say nothing about being licensed to practice law in Texas. And so it's not the same. And she's not representing herself using the name that's supposed to be registered as eligible to practice. She's not even using that name. She's using the alias. So we'll see where all that goes. But, it doesn't take long to find things to complain about. And now it's just a matter of finding an arbitrator to act in good faith to help you get some relief. And that's where we're headed with this. We'll see what happens next. But you get the gist of it, right? If you look at your truth in lending statement, you just read what it says. Let's read it one more time. Let's just look at one. It's always good to Leaving it fresh in your mind, right? That the dollar amount that credit will cost you is $7,737. And the amount of credit provided to you on your behalf is $25,000. So basically, it's a 3-to-1 exchange rate. It's just a foreign exchange. But they should never have taken this number, added it to this number, to come up with this number, and then subtracted your 2,000 and said that you owed this. No, 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 no. I owe you $7,737. And if you want to have it over 71 payments, that's up to you. But, your payments will be based on that number. It's 72 months, not $35,000 at 72 months. Quite a substantial savings. Okay, very good. We're going to leave it there. You all have a great day. And if you find truth in lending, you will own the banker. They're going to need a loan. Okay, y'all have a great day. See you now.